In this video, we will discuss part 3 that we framed on life and personal liberty. So, we have divided it to different parts such as availability, and the second part, live streaming of court proceedings, and the third heading, that is right of appeal, and the fourth heading, right to be defended, and the fifth heading, right to life is not an absolute right, then right to fair trial, then speedy trial, and right of speedy trial. So the first heading that is following under part 3, which relates to protection of life and personal liberty, and in that connection we'll discuss one of the important leading case, and that is Saiba Fakris versus Union of India in 2013. The very decision of the Supreme Court is that right to life and personal liberty guaranteed under Article 21 of the Constitution is available against the state. It is not available against the private individual. And now we'll go to the second heading under part 3, which is dealing with live streaming of court proceedings, and in connection to that we'll discuss one important leading case, and that is Swapnil Tripathi versus Supreme Court of India, and the very decision was delivered in 2018 by our Supreme Court, and the very decision is that in a landmark case where petitioner sought declaration that Supreme Court case proceedings of constitutional importance having impact on public at large should be live streamed for public viewing. The Supreme Court held access to justice can never be complete without litigant being able to see, hear, and understand course of proceedings fast and full dissemination of knowledge and information about court proceedings through live streaming serves diverse interests of stakeholders, as it was decided in this leading case, Swapnil Tripathi versus Supreme Court of India in 2018 by our Supreme Court, and the third one that is falling under part 3 that we framed right of appeal. So, in case of right of appeal, we also discuss one important leading case, and that is Dilip Dhankarkar. So, Dilip Dhanukar versus Kotak Mahindra Company Limited in 2017, the Supreme Court expressed that the right to appeal from a judgment of conviction as under Section 374 of the Criminal Procedure Code is a fundamental right. It is obvious. Neither can be inferred with or impaired, nor can it be subjected to any condition, as it was decided in this particular leading case. Dilip Dhanankar versus Kotak Mahindra Company Limited in 2017 by the Supreme Court. Then the third head, that is falling under Part 3, is right to be defended, and in connection to that we'll discuss one leading case, and that leading case is relating to case Panduranga versus State of Karnataka in 2013. The Supreme Court expressed that it is not obligatory on the part of the appellate court in all circumstances to engage amicus curiae in a criminal appeal to argue on behalf of the accused, failing which the judgment rendered by the High Court would be absolutely unsustainable, as it was decided by our Supreme Court in 2013 in this leading case, K.S. Panduranga versus State of Karnataka. So, in our next important section, that is relating to right to life, is not absolute right. So, in that connection, we'll discuss one important leading case, and that is Asaranjan versus State of Bihar, and it is a case of 2017 and decided by Supreme Court, where it was expressed that the right to life is not absolute right, and it can be controlled by following reasonable restriction. And now we'll go to another facet of protection of life and personal liberty, and that is relating to right to fair trial. And right to fair trial, that is relating to the important leading case, that is Amrinder Singh versus Prakash Singh Bhadak. So, in this important leading case, that as it was decided in this particular leading case, the essence of Article 21 of the Constitution lies not only in ensuring that no citizen is deprived of life and liberty except as per procedure established by law, and that such procedure ensures both fair and expeditious conclusion of trial. So, a procedural law is void if it does not provide for speedy trial. So, also, in another important leading case in relating to speedy trial, and that is Babu Bhai Bhim Bhai Babu Bhai Bhim Bhai Bukharia versus State of Gujarat in 2013, the Supreme Court expressed the same view that speedy trial is a component of personal liberty and that right to speedy trial again it was raised in Hussain versus Union of India in 2017, where it was held the accused has got right of speedy trial when the accused is in custody for long period. Then the court can direct the trial court below for speedy disposal of the case as it was directed and observed by our Supreme Court in this important leading case, Hussain versus Union of India in 2017. So, this is all about part 3 that we have framed reading, analyzing, and explaining the very concept of protection of life and personal liberty as it is provided under Article 21 of the Constitution. And in our upcoming video, we would like to discuss part 4 of this particular right to life and personal liberty, and that we will discuss under different heads. So, in that connection, we'll discuss in our upcoming video.